And you understand, and you can read and write, correct?
To an extent.
Okay. You can't read and write altogether?
Well, I mean, it all depends on what dictionary you're using too.
A regular dictionary.
Then what?
And you read it, it's a regular dictionary, Webster's dictionary.
Yes, I have one at home.
Okay. So you can write too.
I have several different ones. I have Black's Law's dictionaries as well.
I was gonna say,
I've been arrested 7 times now.
I understand
without any victims. I don't understand how the state of Florida, a stack of papers, can be a victim.
okay. All right. So you understand that you could be facing up to 35 years in prison.
Right.
I mean, that's another hearing altogether. You just asked to represent yourself. You're asking.
No, I'm still wanting to represent myself. I'm just about that situation because it's been a conflict, ongoing conflict since
He's your backup counsel right now, but that means it doesn't do anything. If you ever ask for an attorney and you don't want him, we'll have to, and you have a conflict, we'll have to take that up at that time.
First case in Judge Clarke's court today is featuring a hard-headed sovereign man who just can't seem to stay out of the driver's seat, despite repeated court orders prohibiting him from driving. After his most recent run-in with the law, he was caught red-handed behind the wheel again. Judge Clarke is not pleased, to say the least. And what makes matters worse is that it's now come to the court's attention that this man possibly should have never been released to begin with. Will Judge Clarke allow this SovCit to remain free, or will the bailiffs be ordered to take him into custody on the spot? Stay tuned to see what happens. In the second case, we have another stubborn defendant, this time adamant about representing himself pro se due to alleged conflicts with his court-appointed attorney. But will Judge Clarke deem him competent to handle his own defense? Or will the judge insist that he must have proper legal representation?
He was given a notice, conditional release by Judge Campbell. Mr. Thompson, you wish to have an attorney appointed to represent you today? What I'm going to do is I'm going to look at revoking your release because, in my opinion, you should be in custody and should not have been released from custody. I believe this is a new law violation. Is that correct?
A what, sir?
A new law violation. When you're arrested on another driving while license suspended or revoked?
Yes, they were staking out my house, and I don't understand why. I was going to get some food.
I'm going to revoke your release at this time and take you into custody for a violation of probation. Take you into custody.
I'm here to finalize that disclaimer that I have. It's here now, sir. If you
Take him into
would
custody.
accept it, please.
I'm revoking your release. You should have been. You should have been held without bond. He's going to be held without bond.
I'm not going anywhere.
You just give him to his father bearer.
I'll put it.
Can't believe this is happening again.
We'll talk to him again about an attorney when he has a seat up there.
I was down there trying to pay the fines before I came in here, sir.
Mr. Thompson,
Well, they told me to come back
I
after
didn't
this.
sign the warrant. I thought you were being held without bond. I guess I should have checked, but I'd have signed the warrant. You'd be held.
That was because my father, he said, I've been helping with the families that had a pacemaker put in just a few days ago, and I'm trying to help nurse the family.
Put him in the box.
You were taking me away from the
Put him
family.
in the box.
Anything else you property that you want to give?
I got the money on me to pay the fine.
Put him in the box.
I'm sitting right here.
Here?
That's right there.
I need to use the restroom.
We need to hold on.
Mr. Thomas, you before the court, you were arrested on a new misdemeanor charge. Judge Campbell, I think, released you for a notice to appear today, or released you on your pretrial release. This is my probation. I got a warrant, so I'm going to issue a warrant today, hold without bond, based on your.
What is that now?
Judge Campbell, you were arrested on a new misdemeanor driving while license suspended or revoked. Judge Campbell, on your violation of probation, released you. The pretrial release program. I'm revoking that release because it's my probation, and I'm gonna hold you without bond based on the new violation.
That's just terrible.
Well, I can't help it, Mr. Thompson. You've got another
I was here to
charge.
disclaim and surrender all those documents that hold me liable here and move for subrogation.
Do you wish to have an attorney appointed to represent you?
No, sir.
You understand attorneys are, go ahead and swear Mr. Thomason in.
For what reason?
I'm gonna swear you and ask you some questions.
I don't think I'm supposed to be sworn in. In my faith.
Okay, well, I'm going to ask you to affirm, not swear. Okay?
It's the same thing though, isn't it? Affirming and swearing.
I don't know.
I'm here for Let my yeas be a nay and my noes be a no.
Whatever that means. It means
Yes,
nothing to
sir.
me. But what I will
I'm here
do,
for
let me ask
honesty
you, do
and
you wish to have an,
justice.
do you wish to
There's
have,
no justice in
do
this
you wish
house.
to have an attorney appointed to represent you?
No, you keep doing it anyway, though. I mean, I've never authorized that from
Do
the
you wish to
beginning.
have an attorney appointed to represent you?
No, sir.
All right. And how far did you get in school?
So
How far did you get in school?
graduated 12th grade.
Okay, and you were in the military, is that correct?
Yes, sir. I was in the Army infantry.
Okay.
Went to war and buried enough of my brothers and sisters to come home.
Yes, sir.
And this,
And
Justice.
you understand, and you can read and write? Correct?
to an extent,
Okay. You can't read and write altogether?
well, I mean, it all depends on what dictionary you're using too.
If you use, a regular legal dictionary, can you read and write that? Read that?
Say again?
A regular dictionary.
Didn't what?
And you read it, just a regular dictionary, Webster's dictionary.
Yes, I have one at home.
Okay. So you can write too.
I have several different ones. I have Black's Law's dictionaries as well.
I was going to
medical
say, so you can read and write.
Yes, sir.
Okay.
Black's Law Dictionary is a comprehensive legal dictionary used by lawyers, judges, and law students. Sovereign citizens often cite it, believing that if they can manipulate or selectively quote from this dictionary, they can undermine or challenge legal proceedings. Most sovereign citizens cherry-pick definitions from Black's Law Dictionary in order to support their arguments, taking terms out of context or interpreting them in ways that align with their beliefs. For example, they might refer to outdated or obscure definitions of words like person or citizen to argue that laws don't apply to them. By citing Black's Law Dictionary, sovereign citizens attempt to lend legitimacy to their arguments, hoping that their use of official legal terminology will convince others of their position. However, their understanding and application of these definitions are usually flawed or misleading.
All right. I know you've been treated, but I've had you examined before.
100% disabled.
I understand that. I've done everything I could to keep you out of
I've
jail.
already been injured 2 different times at the jails.
I understand that completely, Mr. Thomason. But I've had no luck. Every 2
I
months.
came here
you're back
today
in-
and they told me to come back to complete
Every
it.
2 months, you're back in court. So what I'm going to do you still wish to represent yourself?
I don't, I think that's the best matter for me.
I mean, it's up to you. Right now,
I just still think that's the best matter for me, but
what I'm going to
it
do,
doesn't seem like anything's fair inside this house. Nothing seems fair here.
how many times have you been released from custody in the last year?
I've been arrested 7 times
I
now
understand that.
without any victims. I don't understand how the state of Florida, a stack of papers, can be a victim.
Okay. All right. I'm going to allow you to represent yourself. And what I'm going to do is I'm going to go ahead and have Mr. Thomason evaluated again. Ms. Nelson, if you go ahead and prepare us on the court's own order, I'm going to hold you without bond based on the new
That's just
violation of
terrible.
probation.
My mother's 100% disabled. My dad has a pacemaker now, and you're gonna hold me without
Your
bond.
dad's
over
at court
driving
every day with you. I
infractions.
understand that completely, sir.
There've been no victims whatsoever in any of my arrests.
We're setting for October 23rd at 9 o'clock.
I get another month, thanks. No justice. I have your oath of office. Look, if you would
Somebody can.
adhere
He
to
can
it.
be taken, go ahead and have a seat.
So, Your Honor, where we are in this case, I think we have cases 20-3136 and 20-4047 CF, Your Honor. Mr. Ferreira is the attorney on both those cases. Your Honor, we'd ask for a short pass. There's a report that's being provided to Mr. Williams. There may or may not, a conflict may or may not exist at this point in time that's being determined based on a report that was made to the jail. And so we would just ask to continue for 30 days just so we can get that report.
All right, state's response? Ms. McAfee?
Oh, okay. Apologies.
All right, February 22nd at 9 o'clock.
Thank you.
Yes, sir, Mr. McCoy.
I just proceed pro se, Mr. Clarke. I'd rather not have Mr. Williams represent me at all, sir.
All right, if you will raise your right hand to be sworn in.
Some swear testimony about this truth.
Do, I
All
swear.
right, state your name.
Devontae Jerome McCoy.
Mr. McCoy, you're asking to proceed pro se in case number 20 CF 4047, is that correct?
Yes, sir.
And let's see, you have represented yourself in the past,
Yes, sir.
and how far did you get in school?
11th, sir.
You can read and write,
Yes, sir.
and you're not under the influence of any drugs or alcohol today, which would impair your ability to make this decision, is that correct?
That's correct.
And you have not been diagnosed with a mental illness or suffering a mental illness that would impair your ability to make this decision. Is that correct?
Correct.
You understand attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're to assist you in preparing for trial and preparing for pretrial motions and for other court hearings. And you understand that?
Yes, sir.
You understand you'll be held to the same standard.
Yes, sir.
You also have to do your own research and file your own motions and prepare for trial on your own.
Yes, sir.
I will leave, if I determine that you're competent, I will leave Mr. Williams as backup counsel, but he'll only be that when you ask for an attorney. You understand that?
Yes, sir.
And you understand at any point in time that you're asking for an attorney, that one can be appointed, one will be appointed to represent you.
Yes, sir.
And in case number, unless there's been an amended information, in case number 20 CF 3136, you've been charged with one count of carjacking, which is a first-degree felony, punishable by life. Fleeing and attempting to elude high-speed reckless, which is a second-degree felony, punishment to 15 years in the Florida Department of Corrections and a $10,000 fine. And driving while license suspended or revoked habitual, which is a third-degree felony. You understand that?
Yes, sir.
And let's see. And then you also have another fleeing and attempting to elude in case number 204047.
And when the last time that information has been amended, sir?
No, I said there has not been an amended information. That's what you were charged with.
Oh, yeah, it's been amended. All of them been dropped down to third degree, sir.
Oh, are they? Here's and then that's it. No, fleeing or attempting to elude is still a second degree. That's added. You got a grand theft, which is a third degree.
Mhm.
Another fleeing or attempting to elude, which is a third degree.
Mhm.
And no valid driver's license.
Right.
All right, so you understand that you could be facing up to 35 years in prison.
Right.
All right, you still wish to represent yourself?
Yes, sir.
All right. I am going to find that Mr. McCoy is competent to represent himself, and I'm going to leave Mr. Williams as backup counsel. And what do we need to do at this time, Mr. McCoy?
Well, about a conflict situation, if it shows a conflict, if I was to request counsel, it wouldn't be Mr. Williams, would it?
I mean,
Like, say if, like he
right.
said about the whole conflict.
I mean, that's another hearing altogether. You just asked to represent yourself. You're asking.
No, I'm still wanting to represent myself. I'm just about that situation because it's been a conflict, ongoing conflict since I had it.
He's your backup counsel right now, but that means it doesn't do anything. If you ever ask for an attorney and you don't want him, we'll have to, and you have a conflict, we'll have to take that up at that time.
I've been put in for the conflict a while ago.
Sir?
I said the conflict been put in for over a month now.
I understand that, but you're not asking to file a conflict at this time. You're asking to represent.
No, I've already put in the conflict. The conflict has already been put in with the jail without having Mr. Williams. That's what he was just talking about, Mr. Clarke.
There was just a complaint made to the jail admin, Your Honor.
Well, I put in multiple complaints with the court
Okay,
about Mr.
well,
Williams.
I don't know anything about that. I mean, if you're asking, what do you ask, if you're asking to have Mr. Williams removed and another attorney appointed, I might have to wait till Mr. Williams is present.
Oh, no, we can deal with that when.
You're asking to represent yourself.
I did.
I'm gonna find you competent to represent
Right.
yourself. I'm just leaving Mr. Williams as backup counsel. If there's a reason that he can't represent you, we'll take that up
Right.
if you ask for an attorney.
All right,
Okay?
sir.
All right, now we're set for pretrial. These are old cases. Are we ready to set this for trial?
Set for trial. Well, see, the problem that I've been having is not having my defenses prepared for trial. That's the reason. That's the conflict I've been having with Mr. Williams. I've been asked for my discovery. I've been asked for all my depositions. I've been trying to prepare for trial, but he's not been not having my defenses prepared.
Okay.
I have none of my paperwork. He's not come. He don't come visit me. We don't have any type of
Well,
communication.
let me ask you this. You're representing yourself now. Tell me, we need to set another pretrial, then we need to set it for a trial. How much time do you need in order to set until we're ready to set this for a trial?
But if I can get all my discovery, I'll be ready for trial. If I can get all my depositions, my discovery, everything that I need.
Has there been depositions taken?
Yes, January 15, 2021. I believe it was on the 15th. I know it's January.
You have to file motions to have all those transcribed. They're not just transcribed.
I know that's the problem I've been having with Mr. Williams.
I know that, but you're going to have to do that yourself now.
Right.
Not that I'm your lawyer, but they're offering in April, trying to do that 18 months. It's been about 3 to 4 months. They're offering, that's when they're available. You can take it in April.
Mr. Sullivan?
There have been depositions.
What I'm going to do is I'm going to give Mr. McCoy a month to try to get all those depositions, his paperwork, and then we'll set a trial after February 22nd at 9 o'clock, okay?
Sound good.
All right. Anything else today?
Yes, actually, yes. About my bond situation. Right now it's unreachable.
Okay, well, you need to file a motion to have a bond reduction. Your bonds have been reinstated.
Yeah, it was spoiled and I can't afford it right now.
I understand. We'll have to have a bond hearing on that. Okay?
Therefore.
All right. That'll conclude the hearing. Good luck.
When is my next court date?
February 22nd at 9 o'clock.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.